I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Revocation. What's going on? This is Colin. How's everybody doing? Happy Saturday night. Hope everyone's having a good weekend. I just saw, the Texans are playing the Browns. Hope your team's winning. Whoever's watching, hope your team's winning. All right, I've got a tough case in front of Judge Simpson today. This happened a few days ago, sometime this week. Don't remember exactly what day. I'm going to guess maybe Wednesday. It could have been Thursday. I don't know. But yeah, it's a very interesting case and one that I want to have a lot of conversation about because there's a lot of things going on in here that I don't know enough about to be able, because I'm not a lawyer, obviously, to be able to comment on. But as a court spectator, I've got things to say about this, and I'm sure all you guys will too, especially if you haven't seen it before. And then I've got a bunch of other clips. Go down to Florida for the second half of the video. First case is a fairly long one. It might be about 25 minutes. But before I hit this play button, you already know what to do. Hit that like and subscribe button. Do your jump kick backflips. Let's go.
Okay. It does call the case of the People versus John Torres.
I am going to let this play for a little bit before I pause. I'm going to let him, read off a couple things.
Counsel, you want to state your appearance?
Good afternoon, Judge. My name is Joshua Van Lon. I'm standing in for the attorney of record, Mr. Brian Daly, on behalf of Mr. Torres. Mr. Torres, do I have your permission to do that?
Yes.
Judge, my sincere apologies to this court that nobody showed up earlier. I apologize.
All right. Have Mr. Torres, have you read the pre-sentence report in this case?
No, I haven't.
Counsel, do you know if? Go ahead.
I'm sorry, Judge. It was sent to me. I did talk about it with him, and I talked about the recommendation with him. I didn't send it to him because he was present in your court at the time. And again, I got the call from Ms. Wielding about coming into court. So I wasn't able to send it to him, but I did talk to him about it.
All right. You did discuss it with your attorney.
Oh, there was a notice sent to my attorney from probation officer, and I talked, asked him if he read it, and he read it.
Okay, but did you talk to your attorney about what's contained in the report?
No, I did not.
Okay.
Mr. Torres, the conversation we just had when I got off of Zoom and I spoke with you about what was in the report. Do you remember that?
Yeah, vaguely I did. Yeah, I'm sorry about that. Yeah, I talked to him about it. Yes.
Okay.
Yeah, I'm sorry. I just couldn't.
So you talked about the pre-sentence report?
Yes.
Okay. It's going to be a bit difficult, counsel, because are there any material deletions, corrections, or additions to the report?
I don't see that there are anything that's factually or any deletions or additions that I need. Just disagree with the content of it. That's all.
All right. Go ahead, Ms. Blair.
Yes, Your Honor. I would just like to indicate to the court that the deceased victims' mothers are present and they would like to address the court prior to sentencing.
All right. Very good. Mr. Torres?
Yes.
Have a seat. I want him over in the second seat. Very good.
All right. So excuse me. The information we know now is there are some deceased people as a part of this case. Now listen to the victim's parents. The deceased. Listen to the deceased parents, and you're going to hear how they feel, but then we're going to hear the facts of the case. The facts of the case is what I have questions on. Also, Connie, Judge DeSanto, she had somebody that jumped on her Zoom and played very inappropriate content through the Zoom login, and it was on YouTube, and YouTube removed her channel from YouTube altogether. So her channel was completely removed from YouTube due to someone, playing inappropriate material that wasn't even part of the court hearing. So we lost Judge DeSanto because someone thought they could be funny. It's happened to other channels before. I'm not going to say the P word because YouTube doesn't like that, but that's what happened to Judge DeSanto. People just log in, throw up some P, and yeah. So hopefully she comes back. I still don't think she will. A lot of people disagree with me and think she will. I really hope she does. But yeah. All right, let's keep going with this case.
Okay, who do I have here?
Good afternoon, Your Honor. I'm Rochelle Wilson from the Prosecuting Attorney's Office, Victim Advocate. I've been asked to read the statement into the record, but I'll let the victims' mothers introduce themselves for the record.
Yes.
I'm Sherry Smith. I'm Patience and Deja's mother.
All right.
And I'm Christy Green, Alexis's mother.
All right. Very good.
Well, Thomas Pearson, Patience and Deja's father.
Okay. All right. Very good. All right. Go ahead.
Thank you, Judge. Victim impact statement for the loss of Alexis Hinton and Patience Lunn. Coming up with words for this particular statement was considerably more difficult than we imagined it would be. How do you put a metric or a value on life, on 2 or 3 lives? If we're being honest, it feels like they slipped through the fingers of our society, and it's taken us to a dark place. In a perfect world, we would have all the answers. We would know why John Torres was chasing our girls. It would never bring us peace, but we could find a way out of the gloom and the shadows that the unknown tends to cast. It would give us an opportunity to make decisions with all the truths. Decide if anger, guilt, acceptance, or perhaps forgiveness was merited. And if all are, in what order? Accidents happen every day, but does he bear responsibility for contributing to what happened on August 2nd, 2021? This is the unfortunate side of perception and how subjective it can be depending on one's viewpoint. The justice system is all about what you can prove, but what happens when the evidence falls short of truths that appear certain? This is what happens. We are in court discussing a case where 2 girls were lost and 1 survivor at the age of 15 who experienced unbelievable trauma, diagnosed with multiple sclerosis at the age of 17, and yet remained alive with a daily reminder of what happened. And we are asking for a mere 60 or 90-day sentence to be upheld for a misdemeanor. If there was an exception to be made to increase that time frame, we would ask the court for it today. Now, we have, as a society, have spoken, and we are vengeful. Whether we want to be or not, when terrible things happen to those we love, we inevitably are, regardless of jail time or probation or court-related. We want the guilty to experience suffering in some similar fashion or degree as either the victims or their families have, and continue to endure. Now, ordinarily, we wouldn't wish any suffering on any other human being, but pain and adversity can be catalysts for growth. That being said, the number of days served in jail will never balance the scales of what was lost. Their absence in our world has left a void that cannot simply be filled by any sentence. But as big of an injustice as it was not to have a higher severity of charges, it would have been an even greater insult if the max sentence wasn't applied here. Anyone who has been to the crash site can clearly see that the driveway that was used to turn around, which means the carnage of the wreck that was witnessed before the 911 call. While we typically reserve this word for positivity, we hope that those visual images visit the one responsible daily, just as memories visit us. that the regret of one's actions settle into the soul of the guilty and eats away at their conscience. One can only hope that one day, whether it's tomorrow or 10 years from now, that there will be some level of culpability and contrition here. While we can't promise it will be met with understanding and forgiveness, it would reinforce our faith in humanity. Alexis Haley Hinton, Patience Nicole Lunn, Deja Marie Thomas. In all of this, their names need not be lost when the record is final. Regardless of what transpires today, they are why we are here. Alexis Haley Hinton, Patience Nicole Lunn, and Deja Marie Thomas. Thank you, Judge.
All right. Two of you have asked what's going on. This just started. This is a sentencing. I don't really want to say too much because it's a sentencing. They don't read over the charges in depth. So all I can do is kind of give you an overhead. But I don't really want. It's going to spoil it for a lot of people. So if I give you my opinion now, it's going to change how you're going to view it down the road, and I want you guys to see it how I saw it. But this guy, you know what? I'm not going to say anything more. This is a heavy case, but it's a very interesting case, and you're going to hear more about it. But it just started. This guy took a plea deal to a lesser charge, and 2 people passed away. 1 person's still in the hospital, and these are the parents of the people that passed away, I believe, that are talking right now. So that's what's going on, and I don't, like I said, I don't want to spoil it. There's more is going to come out here in a minute. Fred, thank you so much. Thank you so much. Welcome to Colin. Yeah, my first remonetized Saturday. You are correct. Awesome. Also, Biggin, thank you so much for the raid. Make sure I give you a shout out while I'm paused. All right. I don't want to pause it too much during this. I'm only going to pause it in between speeches if people have questions, but that's all the information I'm going to tell you right now.
Come up to the stand.
But I will unmute my mic for thanks, Bob.
Counsel, is there anything you or your client want to say before I do impose a sentence?
Yes, if you don't mind, Judge, thank you. And first off, it's not lost on me the fact that there are families there that lost their children. And I've been to your court a couple times about this case, and the families have been there, and they've been respectful to me, and they've been respectful to Mr. Torres. So I want to make sure I make that clear. And I mean no disrespect in the way that I advocate for my client. I know you know me, Judge, and I know you know that, but I want to make sure they understand that. This is a case where the prosecution themselves dropped the charges on the reckless driving causing death. My client pled to a failing to stop at a property damage accident. And I don't know how else to say this. I don't want it to sound like there's no empathy in it whatsoever, but there's not a victim to the failing to stop at a property damage accident. The evidence is what it is about what happened that day, and it is sad what happened. It really is. But he's not here because of a reckless driving causing death. He's here because he failed to stop at a property damage accident. And Judge, I'd ask that you sentence him for that. I mean, to ask for jail time, even the recommendation from probation, it just seems, that we're linking 2 things that aren't linked. I mean, this is not, Mr. Torres never would have entered a plea to something that put him at fault for this accident or responsible for this accident. This isn't the accident we're talking about. The accident that he failed to stop for is the rear end collision that happened when he was struck from behind with the truck. It wasn't failing to stop for the accident that resulted in these girls' death. It wasn't that at all. The plea was based on the accident that happened before that. And so, again, I can't state enough that it was painful to read the police report and to see what happened as well for me, and I feel bad for the families. But Mr. Torres isn't here being sentenced for that, Judge. So I would ask that you sentence him to fines and costs, as you would with a failing to stop in a PD accident.
But counsel, let me just I understand, I guess, the argument that you make. But as I understand factually here, there's a rear end collision. And whatever the circumstances that transpire in that sort of brief moment, there is then the vehicle that the victims are driving that goes past Mr. Torres. And then there is, as I understand it, there's sort of this high-speed thing that happens. I guess I say that because it seems to me, and one of the concerns that I have with it, and while it may not, I guess, legally fit within the definition of reckless driving causing death, that but for those young ladies feeling that they were chased, the rest of it doesn't happen. Right? I mean, am I missing something here? Because that's the way that I see it, that had, just by way of example, had the rear end collision occurred, Mr. Torres remained where he is, regardless of what the young ladies did, and they leave. If he doesn't go after them, we don't have the rest of it.
And Judge, respectfully, I disagree. I believe that that's the facts that the prosecution, want, that they have in their police report. I don't believe that's the facts that the evidence shows. The evidence shows that after they took off at a high rate of speed on their own without him following them. Then he took off, and only evidence they have after that is that somebody says from a camera, it appears that he's also traveling at a high rate of speed. But the evidence also shows that none of the vehicles that saw that truck going down the road where it ultimately crashed, none of them saw Mr. Torres's vehicle on that road. He said he turned around on that road, but that was when he lost sight of that vehicle. We have an allegation that there was that he was following them at a high rate of speed, and that's it. But that's after this accident happened, Judge. I mean, that what he pled to was to leaving the scene of the rear end collision. And I don't want to put the blame on anybody in this situation, especially it's such a horrible situation. But I don't think we need to put the blame on anybody for that, Judge, because we're not here to talk about. We're not here to deal with that situation. And I don't think Mr. Torres's actions after the fact did cause or are responsible for that accident. And if they were, I think the prosecution would have at least attempted to prove it. And I don't mean anything negative towards the prosecutor, the way I say it that way. Sometimes when I say things, they come out very, very harsh, and I don't mean that to be that way. I think what we have here is exactly what it is, Judge, an accident. It's an accident. Mr. Torres didn't have any blood, any alcohol or drugs in his system that day. And it wasn't, it was a rear end collision. And I think that they didn't want the cops called on them. And so they took off, and he followed them until he couldn't see him anymore. I don't think that is something that warrants jail.
But counsel, I don't mean to quibble, but certainly.
All right, so let's go over the facts that we just learned. The defendant was originally, it sounded like he was originally charged with some type of manslaughter charge, I'm guessing. I don't think they actually say what the charge was. The prosecution could not go to trial with that because they couldn't prove it. So they gave him a plea deal of failing to stop at a property damage accident. That's what he pled guilty to. Now, the car that these girls were in rear-ended this guy. So they rear-ended him, and then they took off. He chased them. I would assume he chased them to try to get their information. Maybe he was seeing where they're going. I don't know. But he, at one point, stopped chasing them, and they got into a car accident, and 2 of them passed away, and 1 of them is in the hospital still. He took this plea deal of failing to stop at a property damage accident, and the attorney's fighting to not allow him to be sentenced based on the fact that these 2 people passed away, because he pled to fail to stop at a property damage accident, even though it was his property. He got hit. He just chased these girls. Again, we don't know why. They don't explain why. But like I said, I'm assuming he's just trying to get the information. I've been a victim of a hit and run before, and I took off after the car. But I was way behind them. After about 2 blocks, I realized I'm not going to catch them. Then I just went back to the scene, and then that's when I called the police. But so I've done that before. I understand. This is why I want, conversation, and I want people to tell me, how do they feel? Would you have done the same thing this guy did? Do you think he's responsible for the death of these girls because he did chase them for a period of time? So what's going on here? I just need some comments, because I don't know. Craig, thank you so much for the super chat. That was very generous. You're always a legend. I appreciate it. I'll read the rest of the new members after this video. I don't want to keep it paused for too long, because I want this to play, and that's why I keep pausing in between people talking. So I'm going to wait until this actual hearing is over, and then I'll thank all the new members and everybody else. But Craig, that was a very generous super chat, so I wanted to call you out. Thank you so much.
In terms of how the court views this, that what I hear you saying, which is different from my impression in reading through the report and everything that I see here, is that the actions, that your client's actions did not cause in any way the victims in this case to do anything. Even if it was, let's say they took off at a high rate of speed, that they continued at that high rate of speed because he was behind them. I mean, what I'm hearing you saying is the fact that your client was there had nothing to do whatsoever with what ultimately occurred.
I don't think that would be an intelligent thing for me to say. You're right, Judge. What I'm saying is, I don't think that the fact that my client decided to follow them after they left the scene doesn't result in them getting in the accident that they got into. The accident, by all accounts, by everybody who saw it, the accident happened when Mr. Torres had already turned around. He was gone already. I mean, it's not that the accident happened because he was chasing them. It's because the accident happened on their own. And
I want it clear, as I read it, that the car with the young ladies continued to proceed because, in the manner it did, because he was behind them. Now, granted that the accident that ultimately occurs may have occurred at a later point, I think is something different, though. I mean, for me, I want to make sure I have it right, but that's, when I look at the report, that's what I see.
And Judge, with all due respect, I don't believe that the report to be evidence in a situation. That was a disputed fact. That's why it was reduced or taken. That's why the reckless driving causing deaths were taken back, is because they couldn't be proven. There is absolutely nothing in the police report about Mr. Torres. Anything that goes beyond Mr. Torres simply following them and then losing sight of them. Anything else is a disputed fact. We would have disputed. We would have taken that to trial. I mean, we ultimately pled because the charge was brought down to reckless driving, and we worked out the agreement to the failure to stop at the PD accident. At no point was this plea ever based upon any actions that were taken after the fact. But even if it were, Judge, those are disputed facts. The fact that they put it in a police report, with all due respect, doesn't make it true. And the fact that the person who wrote the PSI took that information from the police report doesn't make it true. There was a very good argument, very very strong defense that the things that were in that police report actually were not what happened, based off eyewitnesses who saw the truck on the road before it crashed, based on eyewitnesses who saw Mr. Torres, not on that road at all. And so I dispute those facts. And again, I'm not trying to make something that might appear to be non-complicated, complicated, but those facts are one-sided and they are not the facts that I believe should be in this record. And I don't think we've made a record of those facts. The only record that we have agreed upon in the record that we made is that he didn't stop for the accident and he had to return to the scene of the original accident when he called 911.
Yeah, that's the thing. They would have taken it to trial. He got a deal where all of his charges were dropped except for he had to plead to failing to stop at a property damage accident, which I actually believe is a misdemeanor. I don't remember. I think it is. So he's pleading to a misdemeanor instead of taking, this case to trial, where the prosecution would have a very tough time with this case. Yes, people pass away because of this case. It would be very difficult for jurors. I mean, I see both sides, but the defense is saying, why are you holding this evidence, or why are you taking this into account that these girls passed away when those charges aren't before us? He pled to a property damage accident. So that's what the defense is saying. Why are you going to, take this testimony when he pled to this charge? He didn't plead to anyone passing away. And they think that, so I understand what the defense attorneys say. I really do. I see both sides of this case. This is why I called it a tough case. This is one of those cases where I wish I was an attorney because I could walk through everything that's going on, but I'm not. So all I can give you is my opinions. And I see people in the chat are on both sides, and I'm glad they're on both sides. That's what creates healthy and good conversation. And no one's being rude, which is really good too.
So, and Judge, again, go ahead.
So,
I'm sorry, Judge.
I understand that there might be disputed facts, but in order for me to properly sentence, I have to, in my head at least, have some resolution of the facts as they've occurred, or at least how I perceive that they occurred. Otherwise, I just sentence on a charge and forget the rest of it. There are certainly going to be failure to stop and reports that are.
No, he doesn't want. No, sorry, I might have misspoke. With allowing obviously the victim impact statements and the prosecutor bringing up the fact that people passed away, they're asking for the max sentence that he could be sentenced for, because people lost their lives due to this case. So that's what the defense attorney's arguing. They're not asking for higher sentences in the charge. The judge can't do that. But they're asking for the maximum that they could possibly give him because people lost their lives. And that's where the defense attorney's like, this isn't fair because he pled to a property damage accident, doesn't have a criminal record. That's not fair. Otherwise, we would have taken this to trial. We would not have taken this plea deal if you were going to allow this to sway your position on sentencing. I hope that clears it up a little bit. I feel like I talked in circles, but yeah.
An accident that the cars bump each other and one person just leaves, or it's an accident and the person just doesn't report it, they go home. You have those cases, I get it, but this one is very different in terms of what transpired. And what is different in my mind about it is the failure to remain, well, the failure of Mr. Torres to remain where he was, what then happened?
I don't believe that. Oh, I'm sorry,
Go
Judge.
ahead.
I thought you were asking. I apologize. I did not mean to interrupt.
No, go ahead. Go ahead.
I think, you may disagree with my answer, but the answer to that is what was going to happen was going to happen, because our version of the facts, what we believe to be what happened is, I'm trying to walk very fine line here so that I'm not trying to dig into anybody, but the reason that the girls wanted to leave the initial traffic stop is because they didn't want to have the police come, because there were some, they're kids, they were doing some things that kids do, and they didn't want that to be the issue. So when they left the scene at a high rate of speed, the initial accident, they were going to continue to do that because they didn't want to have to go back to that accident scene. Now, that's the nicest way that I can say it. I'm not trying to be rude or to anybody, to the family there, but
No,
they
I
left
get
the
it.
scene because they didn't want to stop.
I get it, counsel, but the problem I'm having here is you're telling me when I read the report, when I read the rendition of what transpired, I shouldn't take into account things that I see here that give me a bit of pause. Because on the one hand, what you're telling me is that the accident would have happened, or that the rear end collision occurs, these young ladies take off, and that if Mr. Torres does nothing, that this would have occurred. What I read, so that what I just stated is on the one hand. What I read and what I'm seeing is the bump in the rear occurs, and then
I will pause it for that because I 100% agree with that comment. It is a very unfortunate chain of events. Let's see what Biggin just said. The black and white to me, if he's guilty of leaving the scene of an accident, that's all. Yeah. So Raven, I saw your message. No, he got hit. This guy got hit, and the people that hit him fled. He chased them, and then they got into a car accident, and there were three young females in the car that he was chasing. They got into a car accident. 2 of them passed away, and 1 of them is still in the hospital. That is the underlying facts. That's all we know. They don't go into very much detail. They do say that he stopped chasing them after a certain point of time, and he didn't see them crash. That is all we know of the details of him chasing them. So that's all we got.
these young ladies take off, but continue doing what they're doing because Mr. Torres is behind them.
But there's nothing
Because
illegal about that.
Otherwise, counsel, and even in terms of just the charge, why the charge really is that he didn't just stay where he was and report it.
That's what the charge is. Yes. The prosecution didn't bring another charge based on the following them. I mean, they withdrew that charge, and there's nothing illegal about following somebody that hit you, to see where you're going, as long as you're not, hitting them and assaulting them. I get that they were probably worried.
All right, I hear what you're saying, but I don't see that here. I'm just going to let you know, that's not what I see.
Can I say something?
Your client wants to speak. Do you have an issue with that, counsel?
Yeah, no, don't say anything at the moment, please. Judge, I think part of the reason that you don't see that there is because you're getting one version of the facts when you look at the police report. The police report doesn't have another version of the facts. Mr. Torres wasn't required to to give a version of the facts or to say anything. And there's no other independent evidence. Even the video that they said showed him going at a high rate of speed, that video didn't show anything. There's no speed limit on there whatsoever. It's impossible to tell. But had this been a sentencing about somebody being involved in causing the death of someone else, that would be what the charge is. And I see your difficulty, Judge. It's tough because this is a sad situation, but that's not what he pled to. And had he known that this was going to be a situation where he has to, answer for, why things ended up the way they did, instead of just focusing on the leaving the scene of a property damage accident, he wouldn't have made that plea. I mean, it's a difficult case, and I know the prosecution had some difficulty, taking those charges away, and I'm glad they did, because it just wasn't something that could be proven. But if somebody rear ends you and then they take off and you follow them, there's nothing illegal about that. And if those people choose to run away at a high rate of speed and get in an accident, that shouldn't be the person's fault who chose to follow them, and that person shouldn't have to go to jail because they chose to follow them. I'm sorry, it is an incredibly difficult situation. It's very painful. It hurt my heart to read the police report also. It really did. And I know people may never see that, but it did, because it's a sad situation. But the solution isn't to throw somebody in jail because they chose to follow somebody. There's just no evidence that he was trying to strike them, or that he hit them, or that he pursued them all the way until the accident. In fact, the evidence is the contrary. It's that they sped away from him, and that he couldn't even see them when he turned his vehicle around. The accident hadn't even happened.
And under your version of this, how far did he follow them?
According to the reports, he turned around on the street well before the railroad tracks, and the oncoming vehicles that passed the truck before it was in the accident did not see Mr. Torres's vehicle on that road. So he turned around before that even, at one of the turnarounds as soon as you get onto that road. According to Mr. Torres, what he said in the report was that he lost sight of them, turned around and called 911, and that's what he told 911. So, and that went along with all of the other vehicles that were coming down the road, was that they didn't even see Mr. Torres pursuing that truck. Nobody saw Mr. Torres recklessly pursuing the truck. Nobody. The only thing that saw is a camera and Mr. Torres' own comment to 911 that he followed them.
Okay, I understand that as you're talking about the idea of recklessness, and I've purposely been avoiding that because of what the charge was and what it's been reduced to. What I'm talking about is something a little bit different. I'm talking about young ladies take off. What happens if he indeed stays where he is? Your version of it, right, we may never know, but
See, I rarely disagree with Judge Simpson. I don't think that's a fair comment. What happens if he stays where he was? He stays where he is, calls the police, there's a hit and run filed. He doesn't have any information of who hit him. Everyone is happy and married right now. That's a possibility. But we don't know. And I don't like the what ifs coming from a judge. And like I said, this is a really hard case, and I see both sides of this. But I feel for this guy, just because I've been in that situation. I've gotten rear-ended. I pulled over to the side of the road, and the person took off, and I chased them. Like I said, for only 2 blocks, and realized I couldn't catch them. They were gone. I hit a light, and they flew through it, and yeah. So I know that's your instinct. Like I wanted to get the information of the car in front of me. If they got into a wreck because I was trying to get their information because they just hit me, I don't understand how I'd be at fault for that. I really don't. It's a very sad story. And I feel for the parents who, who lost their kids. But this is wild to me. Like I said, this is why I want you guys all to be a part of this. And again, let's promote healthy discussion about this. Let's not do anything rash and say anything dumb. This is something I actually want to talk about.
Version is the same thing happens.
And
As
my
I
version is
look
the
at
same thing could
this,
happen.
pardon?
So sorry. I'm sorry, Judge. You're correct. My version is the same thing could have happened. Yes.
And when I read through everything, I'm saying, and I'm not trying to attribute necessarily a level of cause, but that something different happened because he continued after that.
I think in
So
order to
just so that I can finish that point, that makes this a different kind of failure to stop case in my mind. Because if he had stayed, as I read everything, I don't know that the same thing happened.
But I don't think we know that the same thing doesn't happen, though. And that's the thing, is the failure to stop at a property damage accident isn't because they're worried that you're going to take off and chase somebody and have that person get in an accident. It's because they want you to stay behind and to report the fact that there was property damage and that there was an accident. I think what we're doing is we're taking it and we're moving forward with facts that absolutely 100% would have been disputed at preliminary exam and at trial had we known that they were going to be facts that would be considered. And that being the case, Judge, I would have preferred, if these facts were going to be considered, I would have preferred to have an evidentiary hearing on it, or a contested hearing. And that's actually what we initially elected to do before they dismissed the charges. So now those same facts that I initially wanted to contest are being used against Mr. Torres and accepted as true. And I'm not saying you shouldn't be able to do that as the judge. Obviously, you're the decision maker, but that's why we didn't move forward with a plea to anything or with a hearing as to anything, because when we set the case for a hearing on those disputed facts, the prosecution then removed those charges. So everything after this failure to stop at the PD accident, which was a compromise. I suggested that to the prosecutor, who graciously considered it. Everything after that, that's what's in dispute. In my position, judges, it's certainly not fair to consider the evidence as against my client simply for the fact that he chose to plead to something. These are contested facts, and if we're going to have contested facts, respectfully, Judge, I'd ask for an evidentiary hearing on them, or I'd ask that Mr. Torres be allowed to withdraw his plea if we're not allowed to at least contest the facts or put on, to challenge the evidence that the court's relying upon. And I don't think that you're relying upon crazy evidence, Judge. I think you're reading it the same way any reasonable person could read it. But there's also, it could just as easily go the other way. And I don't want Mr. Torres to be put in jail for something that, with a proper hearing and proper evidentiary hearing, is something that I don't believe can be proven. And I think the prosecutor doesn't think it could be proven either, because they're the ones who withdrew that plea or that charge.
Okay.
All right, Sly, thank you so much. I was laughing. I had a point I wanted to make, and I was laughing. Yeah, the what if statements. I want to let you guys know, this isn't the defense attorney that was on the case. This guy stepped in. So you guys are all saying like the defense attorney is doing a really good job. He stepped in for Mr. Torres's actual counsel. For whatever reason, there was a miscommunication. The presiding defense attorney was not there. This defense attorney stepped in, and he's doing this essentially on the fly. He might know all the details of this case. A case like this, I would, they probably talk to each other about. So he probably knows a lot more than just picking up the file. But he's doing a great job for a stand-in counsel. All right, what did Biggin say? Oh, why can't I can't read it? It's hidden behind my little play button. Yeah, I can't. Yeah, Biggin, I agree. It's a tough case though. It's a really tough case. All right, again, all the super chats, I'll read them after this case, and I'll comment on them and say thank you. But I don't want to keep it paused too long. I'm just trying to pause it in between people talking right now. But Ed, thank you so much for the super chat. I'll read it and thank you in a minute or two.
Okay, I hear you.
This is almost over.
I don't know why, and I don't know that it's up to me to try to figure out why charges get reduced, because there are various reasons why that happens. So I don't know. I don't know what was going through the party's mind. I am telling you how I see this case, but I might see it differently. And so right now and you can appreciate this, I'm reading the report, I'm looking at that, I'm drawing my conclusions from it. I'm hearing you where there's a different conclusion, and because they're typically not at our sentencing, I'm not hearing from the prosecution regarding their side. And then if I hear that, then certainly I can, because it's what I do, I can try to resolve that in my head to see if it makes a difference. I think I'm going to need to start out with, I'm going to need a prosecutor present. And if it appears that I'm reading it wrong, I'm reading it wrong. But I'm seeing it a particular way right at this moment. But I'm going to need a prosecutor present. I will leave that to you to make the decision as to whether or not you wish to withdraw the plea and send this back up on either the felony charges or something else. But I can't. I mean, my intent was to follow the recommendation of probation at least. And I hear what you're saying, that if that's what the court's going to do, you want an opportunity to maybe do something different.
So my main concern, the concern was more about the jail. I've talked to Mr. Torres. I'm sure that he doesn't want probation, but sometimes you get probation with a misdemeanor. So I wasn't concerned about the probation, and I could talk to Mr. Torres about whether he wants to withdraw the plea. And I appreciate the court considering my position as well. I just don't want it to be. I found spoken too much on this, and I'm so sorry to take the court's time. But
no, that's fine. I realize that the mothers, and I'm presuming other family members, are here. So folks, I hope there's an understanding as to what the court is saying, and what I'm about to do. I'm not doing it to cause any more distress or angst on behalf of you folks, as well as I'm not trying to do that in terms of Mr. Torres. I just have to, in my head, be clear in terms of what I'm doing. And none of this is easy, but I hope you can at least appreciate that. And that, because this is a hard case. I'm going to suggest, counsel, that maybe you speak with the prosecutor's office so that maybe there can be some understanding that the court can have. I'm going to adjourn the sentencing, and if you can't, then at least you understand where my head is, at least at this given moment. Then you could maybe file your motion to withdraw the plea or do whatever. I mean, I give everybody the opportunity. I will adjourn this to January 24th, 2024 at 9 a.m. Folks, I said everything at 9, but it's set in a different block and time block, and I'm sure somebody will get to you to let you know where that is. Okay. Any questions?
I personally will be present on that day so that I don't have to rely on somebody else to not show up. And I'm very sorry to your court and to the victims' families for having to wait around.
That's fine. Can we, to the victim's advocate, I guess I'm going to put you on the spot. We can make sure that we have a prosecutor here on that date.
Judge, I can do my best to make that request. It may be a little stronger coming from you.
You want?
Is there a way for you to request that?
I think the email will go out right now. Okay, who,
I think Morgan.
would it be Morgan? Okay,
Has appeared on, Ms. Reiser has appeared on this case before, so I'm not certain. Maybe if it goes to both.
of them. Yeah, okay, why don't we send it to Ms. Reiser and to Ms. Barroso?
I think Ms. Reiser
And-
took over for Kirby.
Pardon?
I think Ms. Reiser took over for Ms. Kirby when she left.
Yes.
This,
So why don't we send it to Mr. Ganatra Reiser?
After that entire case, he has to name drop Mrs. Kirby or Miss Kirby, whatever she goes by. He just name dropped her. Not only did we just hear a tough case, but then he made us all remember our favorite prosecutor, at least my favorite prosecutor. All right. I saw someone said they were late. They were wondering what happened or what was going on. Just a really quick recap. Mr. Torres, the defendant, was rear-ended by a vehicle. That vehicle had 3 young females in it. The females fled the accident scene. He chased them. Mr. Torres chased their vehicle, and the young female's vehicle ended up crashing, resulting in 2 of them passing away and one of them still being in the hospital. And I think I heard this is the second time I've gone through, or the third time I've gone through this. I think they said this happened 2 years ago. Did I hear that correctly? Because they said that the accident happened when the surviving female was 15 and now she's 17. So I don't think they said dates, but you put those numbers together, it sounds like it happened 2 years ago. KCC, what's going on? All right, I'm gonna read these super chats. Sorry for not getting to them quickly while the video was going on. I didn't want to pause that because that was a very intense video. So I was trying to pause it in between the comments or in between the people talking. And yeah, all right. Fred, I read that. Jedi with the 5 get this sub. Lori with the $2. Thank you. C Dumps, new member, welcome. I thank you, Craig. Again, thank you, Craig. Kimmy, new member. Peeps, new member. Peeps. If you haven't tried her soap yet, try her soap. Her soap's amazing. C Dumps again with $5. If I highlight this now, will it show it? Nice. If he backed off after they wrecked, if he backed off and they wrecked after, there was probably a reason they rear-ended him in the first place. Yeah, it's still speculation, but yeah, this is why I say, I see the defense's side. I understand why the prosecution backed off and gave him a plea deal, because this would be a very tough thing to prove. Mr. Torres is like, I'm going to take this plea deal because there's, a manslaughter charge on the other side. I don't want to take a manslaughter charge to a jury trial with the potential that could happen, even if there's no evidence for it. That's scary. So you would take a plea deal over a manslaughter charge for a failure to stay at a scene of an accident or fleeing a scene, whatever the charge was. You would take that every single day. At least I would. Heather, thank you so much. Sharing my Discord link. Aaron, thank you for the new member. All right, I think this is when they started. People, yeah, this is when you guys started to be funny. I was trying hard not to laugh. Serious case, and you guys are doing this in the side chat. People left a person at the gas station. This is all I can find. It's funny. Jay Hart, 2 months. You've been a member for 2 months. The funny thing is when I see the 2 months come up, it's like I was only monetized for about 2 months when I got demonetized. So seeing the 2 months come up, even though I just was remonetized 2 days ago, is still kind of funny. Then J Hart with a 10 gifted subs. Thank you so much. Sly, I borrowed two. Yeah, this is when you guys are being funny. All right, the girl sped away before he began following them. There's no evidence they would have quit speeding. Yeah. Then J Hart with 5 more gifted subs. Thank you, J Hart. You guys. Yeah, I understand it. Sparkle Poots makes you do a lot of things. And yes, you can always participate. You don't even have to super chat to participate, but I appreciate it. Thank you so much. Yeah. Sparkle Poots, thank you for making C-Dump smile. Then we got J Hart again, cleaning out Johnny May's bank account. He's going to need that for firewood. Be careful with cleaning out his bank account. All right. That's a good question. That's a really good question. If they would have been caught, I don't know. So if they didn't wreck and, the police caught up with them, who knows what would have happened. And then we got some doubloons. That's a Judge Slavin interview reference. All right, let's go back to. All right, we still have more. I just wanted to read all those off because I don't want them all to build up. And like I said, thank you everybody who donated, who gifted memberships. Welcome all to the new members. Welcome all, to the new members. Welcome, I don't know why that doesn't sound right in my head. All right, thank you everybody for your super chats. Welcome new members. Gifted subs, John J Hart, you're awesome. All right, but we still have more. This video is only a little over half over. That was just the wild one. All right, let's go.
Yeah, okay, good morning. Colin, before you is Michaela Fed in 2 cases, 2399 and 23100.
I'm going to say real quick, for whatever reason, this stream, I went back and I tried to re-record this multiple times. Sorry, not record. I don't do that. I tried to go back and grab it multiple times. That's what I was doing. But the video of this and the voice isn't in sync. And that for one time, this is not my fault. I promise you, this is not my fault. The court's internet connection was messed up this day. Apparently, again, for once, not my fault.
In this case, Your Honor, we've negotiated to an impasse. At this point, there's certain concessions Ms. Fed needs or is requiring, and those concessions the state's not willing to make. So as I explained to her, that's what a jury's for. So we'll just set this on a jury trial, Your Honor.
Okay, what we'll do.
I've got February. I've already got at least one, maybe two. We can do it in April.
I'm thinking April.
Okay.
So what we'll do, you got a question, Ms. Fed?
Yes, sir. It's like, could I do like 5 years probation and anything to let me be like the PTI so I don't end up a felon? I'm 22 and that's my biggest thing. I will do probation for like, it doesn't matter how long, just to end up not being a felon. I don't want a title on me the rest of my life.
I don't get involved with plea negotiations. That's between your attorney and the state. And a PTI, that's something completely up to the state attorney's office, whether or not they want to allow you into their intervention program. I don't get involved in that at all. If you want me to sentence you, what I'm looking at, I'll listen to your attorney, I'll listen to the state. And
the problem with that, Your Honor, is if you sentence her, it will be to a plea of fleeing and attempting to elude. That is by statute.
Is that a second degree?
It is, but by statute, you have to adjudicate her.
Yeah.
That's what I told her. It would be against the law for you not to adjudicate her as a felony.
I don't know anything about you, but the law is the law. And if the law tells me that I have to adjudicate you guilty based on the charges, I'll have to adjudicate you guilty. I can't make any exceptions not to apply the law. So
what about the no contact? We have been together the last 5 years. We work as a team every day.
That's with her co-defendant. And again, as far as I know, the state is not moving from that.
Every day in the same house.
Clement? They have children.
Taking care of our 1 and 2-year-old children.
We can change that to peaceful contact like we did the grandmother. That wasn't one of the things that was asked, I don't think, but.
It was
I would be
definitely
happy
asked.
to do that.
Okay, so it would be
Judge,
peaceful
Judge,
contact.
if I could put something on the record.
Yes.
As well. Judge, Mr. Wilson has worked very hard on this case. He's talked to me about this case probably more than any other case he's had, Your Honor. So I wanted to be sure that was on the record. There's been a lot of concessions given, and we got to the point where no more. So I'll give Ms. Fed a little time this morning if she wants to speak to Mr. Wilson, but the plea offer as it stands is it, or it's being taken off the table today, Your Honor.
So did I hear you right that you were willing to do a peaceful contact with Mr. Clemens?
That's
That may tilt us in the right direction, Your Honor. Let me talk with Ms. Ms. Fed, and maybe we can resolve this today after all.
Yeah, Ms. Fed, I'm looking at the information. That's a second-degree felony. If
So
you
there's
want.
no way I'm gonna get out of this any type of way without a felony.
No. What I'm saying is, Mr. Wilson and Ms. Smith can negotiate a resolution. You can go to trial and let a jury decide whether or not you committed these offenses, or the state can prove that you committed these offenses. And you ask the question, can I sentence you? I'm looking at the information. If I sentence you, it's a second-degree felony, and I have to adjudicate you guilty. Not saying that I have to send you to prison. I'm not sure what your score sheet is, but
Felony title regardless.
but
There's no way.
if I sentence you based on this, you're gonna be a convicted felon.
Well, either way, it seems like I'm gonna be a convicted felon.
I don't know what the plea offer is.
That's what I'm saying. I'm trying to see if I can do like 5 years of PTI, where you do, so don't end up a felon.
I can't say yay and nay on the PTI. That's up to the state.
That's not the offer they've made. That's what I was trying to tell you. The judge can't do that. So I've changed this to peaceful contact with both these people. And it's otherwise what we discussed. If you don't want to do that, we can put you on a trial document.
She won't even let me do 6 years of probation to not be a felon anymore.
Ma'am, she won't let you do anything else. That's it. She just told me you got,
My hands are tied.
There's nothing you can do.
That's it.
No amount of PTI. So I will not have this felony title on me for the rest of my
You
life.
need to talk to your attorney, but you do not qualify for PTI. That's the offer.
And it's gonna be worse if I go to trial.
you can always be found not, man, let's step, there's people trying to work.
Ready, Mr. Peters?
I'm ready, Your Honor. Mr. Willie Hill.
Mr. Willie Hill?
And back before you is Michaela Fed, again in case numbers 2399 and 20.
Yeah, this one's a little different. This is very different than the last one. We just fast forwarded about 20 minutes, I think. It wasn't too long before she came back up. Defense attorney is kind of tired. He's just like, come on. Prosecutor's kind of tired of this. She committed a felony, and she doesn't want to be a felon. I mean, I understand her side of it. Yeah, I don't want to be a convicted felon either. It's weird. It's a weird one.
23-100. In 2399, Ms. Fed will be pleading, it'll be no contest, but she will be, as we discussed, adjudicated guilty. She's pleading to count 1, the fleeing and eluding, which is a second-degree felony. Count 2, the resisting without violence, that will be consolidated. Count 3, the possession of paraphernalia, she'll be pleading to that case as well. Then in 23-100, it was originally charged as a felony battery over 65. She'll be pleading to the misdemeanor battery. So that is now a first-degree misdemeanor. She should do 2 years of community. Again, she's adjudicated. She should do 2 years of community control with curfew and ankle monitor, followed by 2 years of regular probation.
I didn't get the ankle monitor part. I'm so sorry.
Oh, no, you're fine.
Come on, who's gonna hire me?
This is your
Being a
life.
felon with ankle monitor.
Yeah, can we get a trial date?
I want to, I need some more time to talk. You want to come back?
I was told that she is now probably a minute over the deadline she had to accept this offer.
Ankle monitor for how many?
Judge, at this time, the state withdraws that plea offer that was just read out by Mr. Wilson and requested trial date.
Told you what you were going to do.
Ms. Fed, do you need some time to talk to Mr. Wilson? The state looks like they want to pull this off the table. You can accept the state's offer. These are your options, Ms. Fay.
Can I ask you personally, which one do you think is gonna be worse?
Ma'am,
Do you think it's gonna end up way worse?
No, you can't ask the judge. You have a defense attorney. You can't ask the judge. You know what? When I first watched this, I didn't think, she gave off Karen vibes. I just thought that the comment I showed a little bit before, she seems to know a little bit about the court system. Yeah, I would be fighting to get the felony dropped to a misdemeanor too. I understand that. I would be doing the exact same thing. Anyone that's a court watcher would be hoping for that exact same outcome. And I don't want to spoil it. I don't want to say something that maybe they already said or didn't say. I mix. Yeah, you know what? Let's just play.
I can't predict I can't predict the future. I'm not sure what a jury's gonna do. I don't know
I
anything.
need to get a law school.
Miss Fay, listen, ma'am. Miss Fay, listen. I don't know anything about the facts of your case other than what I've read in the complaint affidavit. So other than what the police said, that's the only thing I know. You have a good lawyer. He will if you go to trial, he will represent you. He's done it hundreds of times before. He knows exactly what he's doing. I don't know what a jury would do. That's one option. The second option is to accept the state's offer. What will happen, I'll ask you some questions to verify this is exactly what you want to do, that you're doing so willingly, no one's twisting your arm, that you know what you're doing, and I'll accept that. The third option is you can reject the state's offer, say you don't want to go to trial, and you can say, Judge Collier, sentence me. Again, I don't know anything about your background. I don't know anything about you. I can tell you with the information that's charged, you have a second-degree felony, and the law in the state of Florida is I cannot withhold adjudication on a second-degree felony. So I will adjudicate you guilty. You'll be a convicted felon. The other conditions, whether or not I send you to prison or probation, I don't know. I'll tell you, the last time someone appeared before me with a high-speed reckless fleeing or attempting to elude, I'll just say this, he's not home, and he ain't coming home for maybe another 6 years or so. Not to say that's going to happen to you. I don't know.
So it's serious. And it's a very serious matter.
It is very serious.
Okay. A second.
Can I proceed? So it's the 2 years community control with curfew and ankle monitor. There is nothing else, and everyone in this courtroom is waiting on us. We're acting like a couple of fools up here.
No, you're fine.
Can we get rid of the ankle monitor? What is the ankle monitor gonna help me?
Miss Fed, don't talk to me anymore. You're represented by counsel.
This is inappropriate.
But y'all want to come back? We'll leave that open till tomorrow. No, okay.
Did you? I'll take it, but come on, what is the ankle monitor gonna do?
How I can't get involved in plea negotiations. That's Ms. Smith. Ms. Fed is asking that you remove the ankle monitor. The answer, the state said no.
That's right.
Okay, it's on the record, no.
Okay. I wear the ankle monitor. Q Dura.
Court costs and fines, restitution that says to be determined. There was no damage that I know of, but there could be investigative costs. I don't know. $100 of public service, cost of supervision, drug and alcohol evaluation and counseling is recommended, zero tolerance. DMV may apply additional penalties, time served on the misdemeanors, DNA sample, testify truthfully against Ricardo Clemens, no only peaceful contact with Deborah Williams and Ricardo Clemens. Count 2 is resisting an officer without violence is consolidated. I believe I already read that into the record. Is that your understanding of the plea, Madam Prosecutor?
I'll try to get through this. Ms. Fed, you raise your right hand for me.
I'll pass it up.
Except, what am I supposed to say?
Sonnenberg from the text where you shall give me the truth, the whole truth, and nothing but the truth. So God.
Ms. Fed, is this what you want to do, ma'am?
No.
Okay.
But it's what I gotta do.
No, it's not what you got to do. If this is not what you want to do, I can't accept your plea.
I just don't understand why. I'm gonna be a felon. I'm gonna be a felon, obviously. So what does the ankle monitor do?
That's not the case. You can always go to a jury trial, and I can tell you, listen, I've been in trials that I thought a jury's gonna come back with a guilty verdict, they come back not guilty. Been in trials that I think they're gonna come back not guilty, they come back guilty. You never know.
So you're telling me I could take it to trial and still end up not being a felon? There's a chance that I could get out of this without being a
You
felon.
can go to trial, the state will have the burden to prove the case against you. Mr. Wilson will stand up, cross-examine.
Take me to trial.
Okay.
Take me to trial.
Okay, I think based on what's happened today, and Ms. Fed basically telling me she doesn't even want to accept this. I don't think it'd be knowing, intelligent, and voluntarily entered into, even if I
understand,
accepted
Your
it.
Honor. That's kind of what I
I
thought when we
like it.
stood up.
So what we're gonna do,
I don't make it work for myself.
but we're not saying you're gonna make it worse for yourself. That's a right that you have. You never know what's gonna happen. So what we're gonna do,
You can destroy
Um,
that.
Ms. Fed, we're gonna place you on the April trial docket. That's 4/15, and we're gonna come back. Y'all gonna come back in March 8th.
Judge, there's, the pleas off the table. There's no need, Judge. We can just put her on the April trial management and April trial.
I don't have an April trial management. That's all.
Okay, that'll be fine.
March 8th.
And I was gonna start putting the trial managements the month before trial to give you an opportunity. Because usually we fill up that trial docket to give the state and the defense a chance to see exactly what's gonna go to trial. So we'll place you on the 4/15 trial docket. We'll bring you back March 8th at 9:30 for trial management, okay?
Raven, that wasn't nice. No, this just happened. I think this happened on Thursday. There's no update on this. They set it
All
at
right, Ms. Fed,
trial.
just make sure you stay in contact with Mr. Wilson. I know this offer may not be what you want. He's a good attorney. Stay in contact with him because you're gonna be in trial.
Because then if I take it to trial, like the battery, every charge will be on trial, right?
That's correct. You'll be facing
So I
everything. There'll be no amendments.
But we wouldn't try them both together, so, but the state would choose, but right now you're charged with aggravated battery on a person older than 65.
Exactly, and that's what's scaring me.
And the state will basically decide whether or not to take that to trial or take the fleeing or attempting to elude to trial, and we'll talk about that in March.
So y'all will decide to take it to trial?
No, you have two different cases. And the state, we're not gonna try both cases during the same week. So the state will either say, Judge Carey, we're gonna take this case to trial, which is the fleeing or attempting to elude, or we're gonna take the aggravated battery to trial. So they'll pick and choose which one they're gonna take to trial in April.
Okay.
And we'll try that case and we'll see what happens. And then you'll still have another case that's out there. And depending on what happened in this case, the other one can be resolved, or we'll go to trial on the other case in the future.
All right, let's do it.
Do
Trial.
trial? Okay, then you're free to go.
All right.
All right.
Thank you.
Thank you, ma'am.
Mr. Rogers?
Mr. Rogers. Not the next case. Yeah, the final two cases are in the same courtroom. Just two quick ones. Probably 2 5-minute hearings. Both of them are good. And one of them goes to jail. Let's go.
Judge, last time I talked to Mr. Richter, he has some potential defense.
The next January 4th. I didn't hear January 4th. Maybe the judge mispronounced. So the Judge Simpson clip I played was on either Wednesday or Thursday. This happened, I believe, on Thursday. This entire docket I have from this courthouse was Thursday. They were both after the 4th. So maybe he said January 4th and didn't mean to say it. That's my only guess. But thank you so much for the super chat. I also feel like I missed another one. While I'm paused. CYP. Cellulite Yoga Pants. Member for 1 month. Thank you so much. And Jonathan gifted another membership. I don't know if I thanked him for that, but Jonathan, thank you so much. All right. Let's continue on with this docket. This guy's out there.
Witnesses he was going to get me information for, and I've not yet got that information. So I would ask that it be reset for February the 8th. And I'm gonna set Mr. Richter an appointment for him to come in and we'll talk about those witnesses again.
Any objection, Ms. Smith? Mr. Richter, we'll see you February 8th at
I
9:30.
was actually hoping we could get a motion to dismiss and maybe I could speak of the incident that occurred. My father, I was
One-
actually
one- we're-
spoke to due to a
Mr.
hearsay
Richter,
statement.
Mr. Richter, one moment.
And,
Mr. Richter, listen to me.
I'm listening.
We're recording this proceeding. Anything you say may be used against you. I advise you not to talk about your case. You can speak with Mr. Hill. You have an attorney and you can speak with him about filing whatever motion you need to
I
file.
wasn't indicted on any criminal charges. The officers came to talk to me.
Raise your right hand, raise your right hand for me.
Promise swear affirm to what you give this call, the truth, the whole truth, and that's what you said.
So help me God.
Mr. Richter, did you hear my advisement to you, sir, not to talk about your case?
Yes, sir.
And you understand that we're recording this?
Yes.
And you understand that the state can use this against you?
Well, the truth cannot be used against me, but.
You understand that your statement,
Yes,
whether it's the
and
truth or
regards to
not?
Miranda rights.
Mr. Richter, do you understand that what you say in this courtroom can be used against you?
Mhm.
Is that a yes?
Yes,
Do you want to speak with your attorney before you tell me anything?
I've already spoke with them about this. I should be acquitted for this.
I'm
because
listening.
I cooperated with the police. I told them I had to get medical documentation. When I stood up to go get medical documentation out my residence, they put their hands on me and tackled me to the ground. And then one of them started punching me in the face. So I was actually assaulted by the police. A paramedic or a medical personnel should have came and addressed me with the incident, but
Judge, Mr. Richter, I'm gonna stop you. The judge has already told you one time, you got a right to remain silent. I'm gonna tell you again, you have a right to remain silent. If you keep talking right here in this courtroom with the video recording, you are going to dig yourself a hole that you might not get yourself out of. If you want to keep talking, you can keep talking, but you've been told twice, you've got a right to remain silent, and I would advise you to exercise it. If you want to keep talking, keep talking.
I was just saying, like, it should be dismissed because I wasn't indicted on any criminal charges. They came to assist me to get to a hospital and they actually put me in jail.
You and I discussed that.
Talking about medical documentation.
And you and I discussed that on the phone, and you told me you had some witnesses and you would get me that information, and you've not yet got that information to me. So I'm asking the court for another court date for you to get me your witness information. And when I have it, I will gladly
Do you
contact
have
him.
your personal phone number?
You're not getting my personal phone
Or your
number, sir.
business number for the public defender's office?
You've had it, but you'll step right over there. We'll make an office appointment for you to come in and see me.
All right. Write the number down.
I'll let you, I'm glad you write the number down. It's 229-9600.
9600.
Yes.
Mr. Richter,
Sir.
Mr. Hill knows exactly what he's doing.
Well, I
Listen-
understand. I was just trying to say that I really didn't do anything wrong. I was attacked
I know,
by the
sir.
officers.
But you have an excellent attorney represent you. Listen to his advice and we'll go from there. You'll probably benefit from listening to your attorney.
All right, thank you.
All right, we're moving to the last case of tonight's video. We're still in the same courtroom. This last guy, you know, he gets arrested. Just so you can look forward to that. Do have someone getting arrested. I just saw a super chat roll by. See Dubs. Sorry, I thought I heard the last case. The next day was January. Yeah, they may have said that. No, Mary. Sorry, I was reading the same one from the last one. Mary, thank you so much. I've enjoyed this tonight. I believe you're growing well in the hosting. Thank you so much, Mary. I hope you're having a great night, and I hope you're doing well. If you ever need anything, and you're on Discord, feel free to reach out to me. I'm always there. Literally, I'm always around Discord. So if you have it, feel free. If you want to email me, my email is in my about page, and if you ever need anything, just feel free to reach out. All right, last case. I'm gonna let this play through. And then, so I'm going to say my goodbyes now. We're rating Katie Zed tonight. It looks like she has a members only stream though. That's the only person I have on my list that shows up. I don't know if it's members only because I don't think I'm a member unless I was gifted one. So we'll see if it actually redirects us. I don't know, but that's the only person live right now. So that's who we're going to rate. Anyways, thank you everybody for all the love tonight. Tonight was an amazing stream. Everyone that super chatted, everyone that was here, everyone that liked, everyone that commented. everyone that's just sitting back watching and listening. I appreciate each and every one of you. All of you are awesome. I hope you all have a great rest of your Saturday night. I hope you have a great Sunday. Be safe. Remember, you don't want to end up on my channel. I will cover you. I will. I promise I will. I'll be polite about it, but I will cover you. All right. Let's let this run out. It's only about a 3-minute clip. So until next time, bye.
You're good.
Thank you. That's it. Can you print that on there so I can make sure I'm coming?
Judge, this is Mr. Gerald. He is, he's on the trial management for this month. Next month, and I would ask that he remain there. It's my understanding he's supposed to come back tomorrow for a motion hearing because over the Christmas holidays, he picked up new charges and the state moved to revoke his bond, was the notice I saw this morning.
Judge, I don't know if that's been signed yet or not by yourself or Judge McFarland. I want to say Judge McFarland signed the order revoking his bond in the county court, so we would ask that he be taken.
All right, sorry, I'm going to pause it one more time because I will say if the KDZ thing doesn't work out, we will be in Discord, and I will be in Discord shortly after that anyways. So anyone who wants to come hang out in Discord, we always hang out after the show. I like rating people, show them some love, and I just want to hang out for a few minutes, say hi to everybody. But after this stream's been going on for an hour and 20 minutes, I just generally hang out for a few minutes, say hi, whatever, and then I jump to Discord. So if you guys want to join me on Discord, my mods will drop the link. I'm fairly certain of that. Now, until next time, bye.
This was only a misdemeanor traffic violation. That should revoke the bond.
Any type of criminal charge you get, you're going to revoke your bond.
And
If
this
it's
the thing, too, the traffic came from this case right here. It stemmed from this case. That's what violated my bond. Or that's what violated my license. And this is an ongoing case. Like, how can they violate my license in an ongoing case?
Judge McFarland issued a order. He issued an order. I don't question Judge McFarland. If you can appear before him and ask whatever questions, but I'll see you tomorrow at 9:30.
I saw where you were arrested over the holidays for
Driving on suspended license, and this case is what?
This case is what suspended your license. So your license was suspended and you got stopped for driving on a license?
Yes, sir.
Okay. Yeah,
Well, I know he had some other tickets. He got other tickets when he got this that were just pay tickets.
Okay.
This is just a pay ticket too, right?
These are court tickets. That the ones that suspended the license was unlawful speed.
And this is what came from this case. He claimed that.
But those are infractions that you pay.
But
Within
if I
30
pay
days.
this, and
They don't have any.
I'm not found,
and
I'm found not
running
guilty of the charge,
He
then
got 2 infractions, unlawful speed and running stop sign. They didn't pay. That
Suspended
his
license. Okay. Well, I'm like I got some paperwork I need to get a hold of and find out exactly what all you've got against you, but if Judge McFarland signed an order to take you into custody, you'll have to go to jail and we'll sort it out from there.
Well, I'll see you tomorrow morning at 9:30.
Then he had a resisting without violence and possession of 20 grand.
if he's saying that I was driving the car and he pulled the car off with going 35 and the 25, and I'm saying that I didn't drive the car, I'm not the person driving the car, I cannot pay a ticket and I wasn't leaving the person.
That's your
Mr.
defense.
Yarrow, listen, Mr. Yarrow, in this case, you're let out on bond in the case that's currently pending before me, under the conditions that you not violate the law.
And I never got the ticket. I never was presented with the ticket.
We'll take that up tomorrow. Judge McFarland already has an order. I'll take up tomorrow whether or not I'm going to revoke your bond in my case, okay? I'll listen to your arguments tomorrow.